Okay, guys, we've got a new lawsuit filed against Donald Trump, Rudy Giuliani, Proud Boys, and Oath Keepers by Bennie Thompson. Bennie Thompson is a representative in the United States House of Representatives, and he is suing these guys for conspiracy to prevent him from casting his vote for the electors for Joe Biden on January 6, 2021, related to the Capitol riots. Okay, the allegation is that these guys all got together and generated a plan that would prevent him from enacting his right to cast a vote, or to certify the votes, I guess more appropriately, on January 6th. This is a 30-page lawsuit. We're going to look at 2 pages of it, and in this very short video, I'm going to tell you exactly why this lawsuit will fail. Despite all of the ridiculous and pomp and circumstances and everything else, this lawsuit is fatal from the start. So hang out through the entire video and I'll tell you exactly why. Why am I doing this? Hey, I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer and I'm a legal and political commentator here on YouTube. So if you like legal and political commentary, analysis, news, opinions, all of that stuff, hit the subscribe button and that notification bell so you don't miss an episode. All right. And look, I'm going to tell you why this lawsuit fails. And it's not because I'm some special lawyer or some crazy cool legal theorist who came up with an idea. It's because this lawsuit was written deficiently. And anyone who can read law will know this if they do the slightest amount of actual research into this. So Bennie Thompson should be embarrassed by this. But let's take a look at the first page here, which just really this first paragraph is where we'll get a feel for what the case is about. Then we're going to look at the statute. Then we're going to go all the way to page 30 of this document. And then we will know exactly what the score is as far as what they're asking. And then I'll tell you why it will fail. Very simple, straightforward. It's like a high school speech. I've told you what I'm going to tell you. Now I'm going to tell you, and then I'll tell you again in the conclusion. Introduction. On or before January 6, 2021, the defendants Donald J. Trump, Rudy Giuliani, Proud Boys, and Oath Keepers conspired to incite an assembled crowd to march upon and enter the Capitol of the United States for the common purpose of disrupting, by use of force, intimidation, and threat, the approval of Congress by Congress of the count of votes cast by members of the Electoral College as required by Article 2, Section 1 of the United States Constitution. In doing so, the defendants each intended to prevent and ultimately delayed members of Congress from discharging their duty commanded by the U.S. Constitution to approve the results of the Electoral College in order to elect the next president and vice president of the United States. Sounds very, very intimidating. Let's take a look at the statute they're citing. It's 42 USC 1985, subsection 1, enacted as the Ku Klux Klan Act in 1871. And the reason I bring that up is because it's very, very important to this. Now, it's not listed as the Ku Klux Klan Act in the Federal Register. It's listed as 42 USC 1985. And here it is, subsection 1, preventing an officer from performing duties. If 2 or more persons in any state or territory conspire to prevent, by force, intimidation, or threat, any persons from accepting or holding any office, trust, or place of confidence under the United States, or from discharging any duties thereof, or to induce by like means any officer of the United States to leave any state, district, or place where his duties as an officer are required to be performed, or to injure him in his person or property on account of his lawful discharge of the duties of his office, or while engaged in the lawful discharge thereof, or to injure his property so as to molest, interrupt, hinder, or impede him in the discharge of his official duties. That's a mouthful. Basically, it says if you use force, intimidation, or threat to prevent someone from doing what they're supposed to do officially in their official capacity, like a representative voting on or casting their vote on the electoral college results, then you're guilty of this. It seems very straightforward, but it's not. It's not so straightforward. Not at all, actually. Okay, we're going to go down to the causes of actions. Violation of the Ku Klux Klan Act. This is, again, back to the document. This is page 30 of the complaint, and this lays out the actual charges. So under the act, defendants may not conspire. You know, we already read the language of it just a second ago. So this is just rehashing that language. Now they're saying defendants Trump, Giuliani, Proud Boys, and the Oath Keepers plotted, coordinated, and executed a common plan. This is an element of conspiracy. You have to show that they got together to further an unlawful act in some way, or a tortious act, or whatever. In this case, a tortious, unlawful act. It's kind of both. In furtherance of the conspiracy, Trump and Giuliani engaged in a concerted campaign to misinform their supporters and the public, encouraging and promoting intimidation and violence in furtherance of their common plan to promote the re-election of Donald Trump, even after the states had certified election results decisively showing he lost the election and disrupt the legally required process before Congress to supervise the counting of the Electoral College ballots and certify the results of the count. As a result, they acted beyond the outer perimeter of his official duties and therefore is susceptible to suit in his personal capacity. Okay, so they do a bunch of work to try and establish a conspiracy. They do a bunch of work to say that Trump isn't acting as president, because if he was acting in his official capacity as president, he might have sovereign immunity. And so therefore, they want to avoid all that. But all of this is irrelevant. All of this is irrelevant. The merits of the claim are irrelevant. All of it's irrelevant. And let me go ahead and tell you why. It's because they don't allege one very specific thing, which is actually a requirement for bringing a 1985 claim. Okay? To bring a 1985 claim, you must allege a discriminatory animus towards a protected class. Remember when I said it was important that this was the Ku Klux Klan Act of 1881 or whatever? The reason that's important is because the entire intent of Section 1985 was to enforce the newly passed 13th, 14th, and 15th Amendments, and to create a cause of action whenever one of those amendments were violated by a group of actors. The entire idea following Reconstruction was not just that they put down rights for African Americans on paper. It's that they actually enforced those rights, and if they were not enforced by local officials, you could bring a private cause of action for the enforcement of those rights. Because in the 1880s, not all police were willing to go ahead and help out black people. I mean, that's the long and short of it. I don't think this is a secret. Some states were better than others, but almost all of them were pretty bad. So they wanted to create a private cause of action, which means, now this does not mean that this statute only applies to African Americans. It actually applies to any protected class, which could be race, gender, national origin, all of those different things that you've heard in Title VII. All of those things are protected class. However, what it does mean, what it absolutely means, is that a failure to allege a discriminatory animus means the case fails on its face. There is no claim. This is subject to a Section 12b-6 motion to dismiss, failure to state a claim upon which a court can grant relief. And there's nothing else to it than that. If this statute is not designed to grant the relief that they're asking for, the case is pointless and should be removed. And you don't have to take my word for it. There's all sorts of case law on this. We've got Cronin versus Town of Amesbury, failure of police chief to allege discriminatory animus against that the town that terminated him was fatal to his charge that the town conspired to deprive him of rights or privileges. We've got Green versus State Bar of Texas, Avila versus City Mortgage Incorporated, Musilla versus Lock Haven University. The cases go on and on and on. The complaint must allege a discriminatory intent or purpose behind the deprivation of rights or the interference with duty. That's how it works. And if you don't do it, you fail. This case fails because Bennie Thompson, I don't know if he didn't hire a good lawyer or what, they just failed to do it. Normally, I would say that, I'm not a big fan of like race-based laws or whatever, but this one does exist. That was the purpose of it. And if you're going to file it, allege the discrimination. All you have to do is allege it. And they didn't. Anyway, hope you found this interesting. This is why this suit against Donald Trump will completely fail. And aside from the factual scenario that Trump and Giuliani can't be directly tied to Proud Boys and Oath Keepers, they would have to have some sort of communications bringing them together. They could still, in theory, like go after Proud Boys or Oath Keepers for organizing the events, again, in theory, of January 6th, but they can't if they don't allege a discriminatory purpose, and they don't. Hope you learned something from this. If you did, hit like, subscribe, share, all of that stuff, and drop a comment down below. Tell me what you think. Have a good day till we talk next time. Peace. Peace.